Hi, everyone. Harry here to talk about new briefing in the Illinois v. Trump case that sets up everything to turn on the statutory question in the law that Trump invoked and the provision in that law that says the president can call out or federalize the National Guard if she or he is unable to execute the laws of the country with regular forces. And the Supreme Court, in a surprise order some 10 days ago, said, we want the parties to brief what regular forces means. And the whole case and its posture kind of changed. And in fact, everyone was able to see the vantage point of the court and where the case could go off in a way not congenial to the administration. Okay, let me set it up, in a slightly more detail. In this case and in others, Trump has again and repeatedly invoked 10 U.S.C. 12406, which gives certain situations where you can federalize the National Guard. One is we're being invaded by a country. Trump's Trumpian flights of fancy can't get there from here, where it's not in play. Second, there's a rebellion. Remember, that's been the focus in other cases. For instance, in Portland, where the courts have said, look, we can be deferential, but not green light circumstances that are untethered to the facts, as Judge Immergan in Portland said. This ain't a rebellion in any way, shape, or form. And, whatever principles of giving a little bit of weight on the scale to the executive cannot reach to that. And that had been the focus of these other cases. Now we have the comparatively sleepy third provision, which is it's a provision all on its own. If this holds, then you can federalize the National Guard, and it says the president can't handle things with the regular forces. Okay. As everybody briefed it, everybody jumped in, and then there was a single amicus brief by a really intelligent, experienced, and respected constitutional law professor from Georgetown, who's been in and out in government, well known to the court, well known to the kind of con law community in Washington. Marty Lederman, someone I hope we'll be talking to later today about this fairly remarkable turn of events. He comes in with an amicus brief saying, guess what? Regular forces encompass the normal military. That means that Trump and the administration have to show that they can't get the job done even with the ordinary military. And obviously they haven't tried either to show it or to do it, and it would completely upend their whole line of argument. And given that the Supreme Court issued exactly this ruling, it makes it seem very likely that they are wrestling with just this point, and depending on how they resolve it, the case could go one way or another. And I want to repeat, this is the case that I've said, the Supreme Court's moment of truth. It's the one that if they go in the unfortunate direction that they have literally dozens of times at this point and defer to Trump, even when it's a fiction, we are really, really hurting as a country, because it would permit Trump to invoke total phony baloney emergency powers and do all kinds of things with them. For example, mess with the elections. That's what I see the real stakes here as being, and maybe the Supreme Court does as well. Okay, so they issue this order, and it's very interesting because it suggests that they're doing what is the best statutory interpretation given the way the court does it of text and history and structure, etc. which would be an exercise in just judicial review straight up, like the court does. What is rebellion? What are regular forces? That would be, almost without regard how they come out, a really welcome development. It would be, in other words, not giving the benefit of the doubt is really too weak, giving the huge ability to just do an Alice in Wonderland fiction on rebellion or regular forces. Okay, so the briefs were due yesterday, and they came in 3 briefs to think about. The United States has its brief, Illinois has its brief, and the little engine that could, professor of common law Marty Lederman has his brief, and it sets out a very stark contrast. I think the administration kind of had it to go this way, unless they were just going to say, never mind. But they've come in with a brief that says regular forces just doesn't encompass the military. And here's why. They try to, first, they repress their argument, the most worrisome and foreboding of all. But it seems to me that the court is past that argument, given that it issued this supplemental briefing order. You may get a couple justices who go for it, but their chief argument, the United States, said you just have to defer. You can't even review it. It's out of your bailiwick altogether. The court doesn't seem to be going that way. It seems to be going on what are regular forces. And so the United States is in a pickle. If they say regular forces encompass the military, they lose. Just nothing's happened. And then I think they lose going forward, because are they actually going, before trying to invoke this emergency power, to bring in the military boots on the ground? That's what they would have to do, and be unable to succeed if regular forces encompass the regular military. Okay. They make, more or less a kind of, you could try to call it a common sense argument, or not a very strong textual argument, but they say, look, the idea is the president can't execute the laws using the regular forces. And when we think of executing the laws, we don't think of the military. Indeed, there's a very strong, tradition in the country against the use of the military in these matters. And you have to consider it as against that point. And that understanding they write is supported in that regular forces condition is in 3, but not in 1 and 2. Whereas if it were really the case that you could get the job done with the military, maybe it wouldn't matter if there were a rebellion, or if there were an invasion. That's what the military storms in. So you can see the point, and it's certainly true that there's a very strong tradition. That's the Posse Comitatus Act, and we've talked about it before, against the deploy of the military and regular armed forces. Okay, but now here's Illinois and Professor Martin Lederman, and they have a straightforward textual argument of the kind that the Supreme Court has applied again and again and again. They look to history of what dictionaries meant at the time with regular forces, and show that what the dictionary meant at the time includes the military. They go to the sort of structure of the text and how it's built up over history, and an earlier version that seems expressly to be thinking about the military, and which was they then re-upped. And the regular forces is most naturally read, they say, and they argue, to refer to members of the standing armed forces. And here are finally historical examples where the consensus understanding of the regular forces, both before and after Congress added the words, include the regular military. So, man, it sets up a really dramatic kind of showdown in the court. This supposed strict constructionist and historical meaning crew, it seems like they would be going for this sort of argument as against the administration's pretty weak argument. On the other hand, it would give a resounding defeat in a big case to the administration, although it wouldn't necessarily mean they couldn't try again, not for the National Guard, but still leave for another day some kind of wide-ranging argument about deference to the executive under another provision that might then give rise to the thing that I and others are worried about, running off to the races to mess with elections and all kinds of stuff. So there's a week now for the parties to reply to the briefs that were filed late last night, and we've got a really interesting kind of rubber hits the road on statutory meaning, including through the filters of history and a kind of paper trail in what Congress has done. And that would foil this wide-ranging, very muscular and dangerous for that reason assertion of executive power by Trump. So it's going to be fascinating in a nerdy way. You can maybe hear it in my voice. Much more important, it could be have immense practical significance and, in effect, close off the so far strongest play by the administration for really virtually uncontained executive emergency power. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.